Good afternoon. Welcome and thank you for joining us for today's webinar on website compliance, key costly legal risks every business should consider. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your moderator this afternoon. We will have interactive polling during today's webinar. To participate, please text the phrase WS webinar to the number 22333. Additionally, our speakers are happy to take questions at the end of the webinar. If you have a question at any time during the presentation, please type it in the Q&A box and we will address as many questions as time allows. If you have any issues with the video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Let's get started with introductions. Today's speakers are Angela Dowdy, Peter McClellan, and Erica Rogers. Angela is a North Carolina State Bar Board specialist in trademark law and a certified information privacy professional who also serves as the firm's Director of Legal Innovation. In her privacy and data security practice, Angela advises clients on all aspects of privacy and security regulations, including evaluating and implementing compliance programs, responding to data breaches and security incidents, drafting privacy notices and policies, and negotiating consumer and vendor contracts. Peter is an attorney and a certified information privacy professional who assists clients in a range of privacy, data security, cyber supply chain, and technology matters. He regularly counsels on the legal requirements and risks associated with the collection, storage, transfer, use, protection, and disposal of data. Erica assists individuals, small businesses, and large corporations with a wide array of intellectual property matters. Her practice focuses on trademark selection and clearance, trademark prosecution and registration, and trademark portfolio management. She also routinely engages in resolving trademark disputes, including drafting cease and desist letters, negotiating coexistence agreements, providing subject matter expertise for litigation in federal court, and handling cases before the Trademark Trial and Appeal Board. I'll turn the mic over to Peter and we can begin.
Thank you so much. So I'm going to start off with a discussion about privacy and website compliance. Privacy law comes into consideration when an organization is using an individual's personally identifiable information. Most websites will collect some kind of information on the users and the visitors of the website, like an IP address or general location information that can be considered personally identifiable. And if your customers or clients make accounts, obviously the website will be collecting usernames, passwords, legal names, emails, and other types of personal information. And while the United States has few generally applicable laws on privacy, all 50 states have laws that come into play when there's been a breach of personally identifiable information. So we're going to start off with a couple poll questions that can get some tangible numbers on how these can impact your business if personally identifiable information from your website gets breached. And then we'll move on to some of the laws to consider when thinking about compliance strategy. So the first one is, on average, what do you think the all-in cost of a data breach is in the United States? We have a couple seconds for some answers to come in. About 500,000, 1 million, 50,000, 750,000, 1.5 million. So millions. It will probably come to no surprise that these types of data breaches in the United States in particular can be very costly. All-in costs will include lost customers, not just the compliance costs. But according to the Ponemon Institute, the average cost of a data breach in the United States is $8.64 million. And that's more than double the global average of 3.86 million. These breaches can be very costly to businesses, and kind of getting a grasp on how to plan for them and how to avoid any compliance failures in the event of them is really important. So let's move on to The second polling question, the cost per record. So a name, an email address, a phone number, all of those are records. And breaking it down per record can kind of give you an idea of, for a small business, what might the cost of the breach be? For a large business, what might the cost of the breach be? Someone said 2,500 in the comments. So cost per record on average globally are $146 according to the same study. But that means that if you have 1,000 people and 5 records associated with them, for example, their name, email address, phone number, age, and billing address, that's 5 records times 1,000 people, that's 5,000 records, and that would be a fairly small company that only has a 1,000 potential leads or potential customers. And when you multiply that by the $146 per record, you come out with a $730,000 estimate for what the breach would cost. If it's 10,000 people, that goes up to 7.3 million. So you can see how these breaches, with just a relatively small number of customers whose information is at risk, can add up in a hurry if you have a lot of person identifiable information on them. And specific to compliance, our last polling question is, what do you think compliance failures tend to add to these costs above the average? So when there is a data breach and then you find out there were compliance failures, what does that tend to add to the cost? $50,000, double, 500. So on average, the typical data breach at that 3.86 million globally, we'll see a $255,000 increase if there's a compliance failure associated with it. That's 6.6%. So if we take that example I gave where 1,000 people have 5 records that were breached, that comes out to about the 50,000 that was the first guess out there. But for the 10,000, it's $500,000 if you use the percentage. But the average was 255,000 according to that study. So with all of that in mind, there is a huge impact that compliance failures and data breaches can have on an organization when they occur. And you'll see in part of this why the United States tends to have such higher data breach costs as well. The established laws that we're going to talk about right now are laws that are in effect today. You can get penalized for not complying with them today. And then after we go through these, we'll talk about some proposals that have been passed but are not yet operative. So in California, they have, it's called the right to know as part of the California Consumer Protection Act. And under the California right to know, company that is operating a website would have to, for example, disclose what information on a person is being collected, the purpose of that collection, any rights that an individual who's a California resident has under the statute, which includes things like being able to access their information, to request that the business delete their personal information, and not to be discriminated against for exercising any of these rights. The law then has what's called a purpose limitation, where you are limited to only using the information collected for the purposes that were disclosed. So if you only said, we are collecting your mailing address in order to ship you the goods that you ordered from our website, and that's all the only purpose you disclosed in your privacy notice, and there was not some other place where they agreed to additional uses, you would not be able to then, for example, mail direct marketing materials to the buyer. You would be limited to the purposes that you disclosed in your privacy notice when they agreed to it. California also has a private right of action. And this is where you can see a decent amount of the increase in American costs because, for example, under the private right of action, if there were not reasonable security measures in place and a data breach occurred, anyone whose information was accessed and was not encrypted would have a right to sue the company who held it and was breached, double victimizing that organization because they had to remediate the breach and now they have to deal with this lawsuit. And they have statutory minimum damages of $100 per person. That 1,000 person example we used before, automatically your starting position is $100,000 that would be owed to them, and it's capped at $750 per customer in this situation. Those fees are increased when it's administrative enforcement, so in the Attorney General of California or the newly created Privacy Protection Agency. When they get involved in enforcement actions, those costs can go up. But the prospect of class actions and individual lawsuits are significant for this type of data breach, especially in California. So the next to talk about is the European Union. The EU has similar laws on transparency and your right to know, but they're not the same. So compliance with one set of laws, for example, the California law, is unfortunately not sufficient to argue that you are compliant with the European laws. The European laws are called the General Data Protection Regulation. And they require transparency about information that's collected, the purposes for which it's collected, who you're transferring it to, and things along those lines. And they have some restrictions, for example, on exporting data to countries like the United States that have not been determined to have adequate privacy protections nationwide. It applies to all EU residents' personal data, regardless of where the business collecting it is based. So if you are a North Carolina-based company, but you sell to French clients and you have their personal information, or French customers and you have their personal information, you are required to comply with GDPR as regards to those individuals. The EU also requires a legitimate basis for when you're going to be processing information, and processing under the EU law is basically anytime you do something with the data. Now, fulfilling a set agreement is one such basis, and that would be, again, the example where you're selling widgets and someone asks you to sell it to them, they're willing to buy, they give you their mailing address and their email address for the receipt. If you have nothing else, you can use the mailing address to ship the widgets and the email address to send the receipt. But without an additional basis, you would not be able to do more, for example, using that information for direct marketing or anything else. Now, you can use consent as a legitimate basis, so long as it meets some requirements that recent court cases in the European Union have said meet the requirements for European consent, and that largely revolves around whether or not it was truly freely given. And so it has to be an opt-in, and you have to be able to use the website or accept the terms without that processing in order for it to be truly freely given in most cases. There have been cases suggesting that cookie banners and privacy pop-ups that are not actively agreed to are not voluntary in this manner, and so you wouldn't be able to rely on consent in those cases as a basis for any further processing. And you would need to have a detailed account of what that processing is in your privacy notice as well. Constructing a properly done privacy notice and getting the consent structure correct is the best way to gather that consent, but you need to make sure that it's done properly, or else you might not be operating on a legitimate basis. And because of the GDPR fines, which are 4% of a company's global gross revenues or 20 million euros, whichever is higher, that can be a significant prospect of future liability. And today, 20 million euros is the US dollar equivalent of about $24.4 million. So next, let's move on to what laws have been passed but are not yet fully operational. So Virginia made a decent number of headlines recently with a law, with the nation's second general privacy law, and it will be coming into effect in 2023. It has similar right to know and purpose limitation requirements. Both of these can be tailored in your privacy notice to only include the residents of the states if that's needed. Other organizations want to have a global policy, and that's a strategy that your compliance, when you're creating a compliance strategy, that's a trade-off that you'll want to consider. The law also requires data protection assessments to be done whenever there's new processing activities involving targeted advertising, the sale of personal data, commercial profiling, sensitive data, which is defined in the law to include certain things like race or ethnicity, and then any processing that has a heightened risk for consumers. Heightened risk for consumers is the term used in the statute, and we don't have much guidance on what that entails, but for the purposes of website compliance, I would suspect that any kind of information collecting that occurs on a website without sufficient security built in place, for example, a transport security layer or similar encryption, those features will probably be an early area of enforcement. One thing to note with the Virginia law is that there is not a private right of action, so you're not going to get class actions or individual lawsuits, but the Attorney General is empowered to enforce the law, and they have the ability to request and review any of those data protection assessments in the course of that inquiry. And then lastly, California has strengthened its law. These changes are not currently in place, but most of the most recent updates will be operative in January 2023 and enforced 6 months later in July 2023. Now, when the first iteration of this law came about, there were some delays and whatnot, but we have no guarantee that that will happen again. Notably, sharing information is expressly included within the definition of selling in the revision. Now, the original classified transfers as selling, so this isn't a hugely substantive, but it answers the question of explicitly whether or not sharing information is going to be covered by this privacy law. What's more, employee data had been subject to an exclusion and an exemption under the past law. It's the California Consumer Privacy Act, but it defined consumer very broadly to include basically every California resident. But employees tend to be producers, not consumers, so there was some question as to the applicability. The revisions expressly sunset the exemption for employee data when the law goes into effect in 2023. So if you have intranet website or some other operation, you're going to want to make sure that that is CPRA is the acronym for the new law. Make sure that that is compliant as well. And it had some privacy risk assessment requirements and an annual cybersecurity audit that was included there as well, which will make enforcement by the Privacy Protection Agency in California significantly easier, and we'll probably see an uptick in enforcement actions on that basis. So with that, I'll be happy to answer your questions when we get to the Q&A, but with that, I'm going to hand it over to my colleague, Angela, to talk about the ADA.
Hi, good afternoon. So it usually actually surprises people to learn that the ADA, the Americans with Disability Act, which was originally enacted to prevent discrimination against people with disabilities in locations of generally open to the public areas, actually does apply to websites and other digital communication means such as mobile sites, applications, So it's always interesting. It's a little different area than privacy, which can be very complex. So while this is a surprising area of law, it's typically one that is easier for clients to implement and avoid some of those trickier and riskier areas. But all organizations, institutions, businesses, any establishment really with websites, mobile sites, or mobile applications that are subject to the ADA have to provide similar accommodations to people with disabilities so that they have the same level of access to the online digital content and services as everybody else. So where this really comes into play and where people are used to doing it in terms of a brick and mortar store and the physical access in terms of, how wide are our hallways? Do we have accessible bathrooms? When you're talking about websites, you want to consider people that maybe have blindness or low vision. If we have deafness, hearing loss, learning disabilities, speech or photosensitivity, all of these things are applicable to the ADA and the websites. And so compliance in this area is important as well. So Jen, if you want to go to the next slide, yes. So what businesses are subject to the ADA? Because this is another area, once I tell clients, the ADA may apply to your website or digital platforms. What businesses are subject to it? And a lot of businesses that have more than 15 employees are already aware of these ADA compliance requirements, and so they're not surprised. And so the first type of organization that needs to be aware of it is 15 or more employees. So if you're already doing this in your physical area, you need to be doing it in your digital platform and online presence. The other place that we typically see ensnaring some of our clients are smaller businesses, maybe healthcare providers or law offices, some of your smaller startup businesses that they don't have more than 15 employees. They don't offer your traditional public accommodations, such as like a retail place, but they do have other public accommodation areas, such as conference rooms, meeting areas. And so if an organization maintains any type of public accommodations for its patrons, regardless of the number of employees, the ADA applies to it. And so it needs to also be considering this for their website and any sort of online digital platforms. So what does compliance require? And that's really where the difficulty comes in for this newer area. I say newer, I should probably put air quotes around it. It's not exactly new. It is an area that's been around for a while, and we'll talk about some of the enforcement that has really brought it to the forefront. But unlike where your physical ADA compliance comes in, where you know how many bathrooms you have to have, you know how many parking spaces you have to have, there's no real legislation or statutory requirements that sets out these are your technical requirements for ADA compliance when it comes to websites or an app or any sort of digital availability. There are, however, what they're called the Website Content Accessibility Guidelines, and it's WCAG because as the law industry loves acronyms, so we can make everything more difficult. But the WCAG are industry standards. They were set by a private grouping of technology and accessibility experts, but they've been widely adopted, including by federal agencies. And we're currently on the 2.1 guidelines. We're expecting even newer guidelines to come out in the next year or so. But these guidelines set out levels of accessibility, and it's A, AA, or AAA. And usually what we tell clients is, in context, federal websites are typically implementing at the AA standard. But we also say take into account what your consumer base looks like, how often they're using whatever the digital platform is or your website, how important is it, how difficult is it to access. So if you're a law firm and it's important for them to be able to contact you or read the materials that are on your website, but they're not really obtaining the service from you, AA is more than adequate. If you are running a all technology business that maybe only has a small accommodation such as a meeting conference room kind of thing, you're going to want to make it a higher level to make sure that it is a better user interface and accessibility. And so since there aren't real standards in terms of you must do X, Y, and Z, there are principles that are set out in terms of when you are assessing your website and you're determining that it is accessible. There are 4 things in which you want to look at. Perceivable. Is your website perceivable? Meaning, is the information and the user interface components presented in a way that maybe somebody that has low visibility or hearing issues would still be able to perceive that information? So, for example, providing text alternatives to non-text content, such as captions for pictures, creating content that can be presented in different ways, right? So you may have put it in a video format, but there may be technology that slows that down, that breaks that down, that removes the music so that somebody that has hearing issues can maybe hear what's being said better. Is it operable? They must be able to operate the website. So that means giving functionality. Maybe everything that's on your website can also be operated by a keyboard, not just a mouse. Giving users time enough to read and transitional content. So can they slow it down so that they can see it? Actively helping users navigate the find content. That's where a lot of these arrows and other visual items that we now see on a regular basis on websites, that's where this came from. Helping your consumers is your information and the operation of the interface understandable. Can they make fonts smaller? Can they make it bigger? Can they take out, maybe you made it in a very stylized manner, can whatever they have on their PC pull that out so that they can have the same access to that information as anybody else? And then is it robust? And that's always the most nebulous. Content has to be robust in that it can be interpreted by a variety of different user agents and assistive technology. And that's really the back end technical piece of this. This isn't a lot of what businesses from a business strategy or a marketing perspective are thinking about. But user agents are software that acts on behalf of a specific user. So for example, one type of user agent that we all use is a web browser. But we have the option of the different types of web browsers. So whether we're going to use Chrome or Firefox, all of your websites should be able to interact with your most standard web browser user agents. And then user-assisted technologies are tools designed to help individuals with specific disabilities. So these aren't things as a business you provide. It's something that the person with the disability would already have on their device, but you have to make sure that your website is designed in a way that it will allow that user-assisted technology to interface with the website. So one common example of a web-based user-assisted technology is a screen reader. And that's software that people with a disability may put on their device or put on their screen, and it converts it into another form, such as text to speech, or they might have a device that prints refreshable to Braille. And again, so this is the robust, meaning if they can interact with it, if anybody can interact with it, somebody with a disability must be able to interact with it in the same way. So is compliance enforced? Because the other thing that we typically hear from a website compliance perspective is this is going to be low priority, right? Like it surprises clients how often ADA website compliance litigation comes up, and it's actually a very regular occurrence. And I will say that COVID and everybody being at home has actually increased the amount of litigation that we're seeing, because people that would normally go into retail stores or brick and mortar, they're just not able to. And so there's becoming more and more reliance on the website. As companies begin to pivot and change their business to an online basis, we're seeing less and less websites that are actually in compliance. Some recent bigger enforcement actions that, and it's spanning a number of industries. You're talking about Zillow. So we've got real estate, and during COVID times, you hear people that they bought homes without ever actually going on site, which to me is, as a Gen X person, is just mind blowing, of buying a house that I've not seen, but people are doing this. Retail, which is really regular, but to hear retail stores like Banana Republic aren't compliant. Entertainers, Beyonce had a suit against her, Domino's. And so these are very big industry players that were not compliant. They were well defended. And most of them resulted in federal fines and obviously a compulsory compliance requirement. And the other piece that we're seeing to this is it's not just big businesses that are being pursued now. What I think some of these smaller businesses are seeing, that as a result of these big businesses not being able to defend themselves, we're seeing a number of class action suits coming out that are going after a number of smaller companies. And it's very easy to determine if your website is compliant or not. There's a lot of different software that can go out on the web just to test websites. And we test websites for clients, and we introduce them to experts that can help them determine and assess their compliance and their risk. And so liability can include a lot of things, especially when you're talking about class action suits. Many times filing a lawsuit when we talk to clients is, it costs a lot of money to file a lawsuit, so the risk is lower. Here's the issue. But when you're talking about class actions, the relatively low entry barrier, you can end up paying attorney's fees for the other party. You can get fined, federal fines. And then at the end of the day, you're still stuck with the cost of making a compliant website. And then oftentimes the Department of Justice or a court may hold you to an even higher standard than if you were already independently compliant, or could at least show steps that you had taken to attempt compliance. So those are the biggest enforcement issues that we are encountering. And then, of course, the most important, risk mitigation. So unlike with many areas of law where we have long conversations about cost and benefit and risk, and the analysis can be a difficult assessment, is the risk worth it to be non-compliant? ADA website compliance claims and litigation, even in cases in which we have been able to prove that the client is compliant, are always more expensive than if a client had proactively built a compliant digital platform. And it's like this because it's worth noting that it is not the use or inclusion of very specific technology, such as those that amplify words or audible versions of content, which is required for compliance. Compliance offers businesses a wide array of options, right? As long as you are compliant across the board in terms of the biggest pieces of software, you don't have to have the most technologically savvy website that's out there or every bell and whistle that ever existed. So I'll leave you with, when building a website or digital platform or assessing existing ones for compliance, think about those 4 standards that WCAG sets out, and it's 4 principles, and reach out to your marketing professionals and those that are hosting your websites. Often they have templates that can assist with ADA compliance. There are service professionals out there that will, on the back end, test compliance. And then on a regular basis, make sure that as your website gets updated or technology changes, that in the same way that you're, upgrading patches and all of that to your software and all your other technology that you would provide to consumers, make sure that your website, your apps, and any sort of digital content gets rolled into that annual assessment. Whether you are completely compliant or were able to fend off, taking those steps and showing an attempt to comply is usually the best and first step. And with that, I will turn it over to Erica so that she can talk about what makes a website pretty.
Thanks, Angela. All right, so last but not least, or else I wouldn't have a job, is applying trademark and copyright law to websites and some compliance issues there and some possible pitfalls. So before going into more detail about what issues are coming up or what we're seeing today, I just wanted to back up and explain trademark law and copyright law as applied to websites so that we are all on the same page as to what we're talking about here. So when you're setting up a business and you're setting up a website, there is going to be intellectual property. Anytime you use a name for the business, any product or service offered is going to be called something, and by offering those services or selling those products, your company is developing trademark rights because trademarks allow customers to identify the source of the products that they're purchasing or the services that they're purchasing. Also allows customers to distinguish between different companies based on the trademarks used. So there's a lot of value in selecting a trademark and protecting that trademark. And these trademarks appear online on the website, prominently displayed at the top of the pages or tied to the products that you're offering on the pages or the services. Both trademark and copyright law applies to websites because copyright law protects the creative original works authorship on the website. So not the names of the products or services, but the display of the website, the artwork used, the text, even the HTML or the source code behind the website. Anything that's a creative work that goes into the website or that consumers see on the website is going to be copyright. So there's also copyright protection involved here. So the first thing when creating a website or even launching a new product or a new service on the website is to make sure that you're not going to run into an infringement risk in using that trademark. And the way that you do that is make sure that that name's available. The strongest trademark is going to be something that's distinctive, inherently distinctive. So something that's a made-up word, something that's arbitrary, not something that's descriptive, but something that is a term that when consumers see it, they're only going to associate it with your company. The issue with choosing a distinctive name, though, is are you choosing something that someone else has already used? So the main risk that you run into on your website, especially because of how accessible websites are, is selecting a name that's not available and running into an infringement risk. When you have done a search or you confirmed that the name is available and there's not going to be an infringement risk, it's a good idea to see is the corresponding domain name available. The value in your website is going to be consistency. So if you have the name of the company or the services, the products, and that corresponding domain name is not available, then you lose the value of that consistency of consumers typing in the domain in hopes that it would lead to your company and not doing so. And we'll get more into that issue a little bit later. And then, so those are both trademark issues, and then something we'll get into later as well is the copyright in the website materials. So, the creative materials, the display, a lot of companies will outsource that work, the design work. So it's important to look into the risk and the issues that would come up if you actually turn out to not own the copyright to the materials that you have on your website. So go to the next slide. Let's do the next slide from this, please. Okay, so going into a true and false question, just to dive into trademark law a little bit more. If you are the first company to file an application to register your trademark, so you go and submit, you see that it's available, you submit the application, are you the company that then owns that trademark? So the first to file. Looks like we have maybe one answer that says that's true. I don't know if anyone else is gonna answer. Okay, here's some more coming in. So you go to file the application with the U.S. Patent and Trademark Office. Right. It's sort of a trick question, right? So that's maybe what some people. So technically that's false, not necessarily. So trademark rights in the U.S. are based on use, not registration. So the first company to offer a product or service under a trademark is going to own the trademark rights, although the trademark rights are going to be limited to the geographic areas that you can show that you've used the trademark. So you launch a product, you start selling clothing online, you haven't gone to register it, but you can show that you have customers in Virginia, North Carolina, South Carolina. You can say that your reputation, your goodwill tied to that trademark are in those states, and then you have what's called common law trademark rights or unregistered trademark rights to those areas. The benefit to registration is that you have the legal presumption of nationwide rights. So of course, there is a benefit to going to register the trademark, but just because you have a registration, it might not mean that you own that trademark everywhere, because there could be a pre-existing user of the name of the trademark for a related product or service, and they've been using it prior to when you went to the trademark office to register it. So it gets a little bit more complicated when you're trying to assert trademark rights and when there's a conflict between you and a third party, because you need to look at who was using it first, for what products and services, where were they using it, how they registered it, and our consumers going to be confused. And of course, when it comes to the online, using trademarks, and we'll get to some more specific issues. Your ability to enforce those trademark rights are obviously going to be benefited by having a registration certificate, because you're not going to have to go back to those invoices and say, listen, this is where I own the mark because I've sold it to these people in Virginia, North Carolina, South Carolina. It's you have that presumption. You can use the registration certificate easily to show that you own that trademark or to enforce that trademark. So there are benefits there. So to get into some relatively new problems for trademark owners, so that there's some obvious things that can happen online. If you have a website and somebody is using your trademark on their website for the same, let's say their clothing products, and they're selling clothing products with a similar name. In textbook, you have trademark infringement. What about some ways that technology has confused the law, for lack of better terms, confused the law here, where is it trademark infringement or not? So, and could you be liable or not? So the first is keyword advertising. So Google has an AdWords program. There's also Bing that has keyword advertising. And something that's challenged courts is whether or not this constitutes trademark infringement. So what keyword advertising is, for those that do not know, is let's say hypothetical only, I'm Coca-Cola, and I want, when people go to Google searching Pepsi, Coca-Cola ads to pop up. So this is pretty common as a way to influence consumer behavior online so that you can compete. Normally, and I think what the design of these programs were, is so that you could put your own marks in there. You would put soda, pop, Coca-Cola, whatever you would want, so that it leads to your advertisements. But of course, people are taking advantage of this program to compete, and courts are split on whether or not it's trademark infringement. What it comes down to is not, is this occurring behind the scenes, but is it in the text of the ad such that consumers are going to be confused? So that's where the law comes down on this, and where it becomes an issue is if, when somebody searches for Coca-Cola someone searches for Pepsi and a Coca-Cola ad comes up that says, Coca-Cola quenches your thirst better than Pepsi. Pepsi, continuing on with sort of unsubstantiated claims about Pepsi. That can cause issues because the trademark is appearing in the ad. It's false advertising because they're making unsubstantiated claims. In that instance, if it's appearing in the actual text of the ad and you're making claims about the competitor that can't be substantiated, and consumers might be confused, then it can raise to the level of trademark infringement. But where it might not be enough to courts is if it's only happening behind the scenes. It might not be enough. Same thing with meta tags. So if you're using an HTML coding, if there's nothing consumer facing where consumers are actually going to be misled or confused, then unfortunately it hasn't, companies haven't been as successful in the courts of saying that that's trademark infringement. But that's not the end of the road if you see that this is happening, because Google actually does have a complaint form that you can use to challenge some of these ads. So if somebody is using your trademark for a competitive purpose and it might cause harm, it might cause confusion, instead of going the legal route, there is a complaint form on Google where a registration number is going to be to your advantage to show Google you own this trademark, this ad's infringing, and using that. So that's sort of the enforcement piece, but then to defend from that, going to Google right away and purchasing a bunch of your competitors' AdWords and trying to take advantage of that is probably not the right move, because there will be some of these advanced companies will have monitoring in place and try to see what's happening and try to prevent that from happening and start enforcing the trademark. So keyword advertising, again, it's something that is the courts are a little split on how, whether or not it is trademark infringement, but the main thing to remember is if the advertisement is likely to cause consumer confusion or likely to create some sort of association, or if it has unsubstantiated claims, then all of those are an issue under trademark law. So then the next thing that I wanted to talk about when it comes to new problems for trademark owners is cyber squatting. So cyber squatting is if a competitor or bad faith actor purchases a domain name using a third-party trademark. So again, it can be used competitively, or it could just be used as a way to maybe profit, but it's very common. We see it a lot. So if you have a registered trademark and somebody is, or multiple people are out there registering names that are similar. So I'll give an example. So Coca-Cola, Coca-Cola.com, that might be something they own, but colacoke.com or colacola.com, some of these names that are similar, you don't need to prove trademark rights to register it, so they're starting to collect it. So what do you do there? And is it trademark infringement or not? So if the names are similar, and the third party is registering it in bad faith, so they don't have any rights to that name, then there can be a way to try to get that registration back through the Uniform Domain Name Resolution Policy. So UDRP, it's through the World Intellectual Property Organization, is a way that you can file a complaint and try to obtain that name back. With the privacy regulations, it's difficult to see who that owner is. So in years past, there could be a way to send a demand actually to the owner of that domain, but because gaining that information has become so difficult, it seems that the best way to go after these cyber squatters is through the EDRP, and try to gain the ownership of the bad faith domains. And sort of related to this is, so maybe there's the obvious infringement where someone has no legitimate rights. They're just trying to maybe own it and sell it to the trademark owner. There's some obvious ways that this is trademark infringement, but something we see also is maybe a distributor or a prior distributor. So if somebody was authorized maybe to use the trademark at one point, that they were a retail store, let's say they were a distributor of the product, and you terminated that relationship, but then they use a similar domain to forward to their website. So we actually see that happening, and that is classic trademark infringement, because you're using a trademark that is not yours in an unauthorized way to forward customers to your own website, potentially confusing them. Because if you use a trademark that you don't own to try to maybe suggest that you are associated with that trademark owner and you're not, that's classic trademark infringement. So both keyword advertising, cyber squatting, ways that potentially could cause some infringement risk. It seems like taking advantage of these technologies it is easy. So it seems like a good idea to try to redirect some of this online consumer behavior to your own website. But because of the way that trademark laws apply to these, to both of these programs, there's definitely some risk of a demand of a UDRP complaint, of a complaint through Google, ways to try to remove and restrict some of this type of advertising that does or can violate trademark law. Okay, so that was trademark law. Let's move a little bit into copyright law. Going back, copyright is not a trademark, but it is copyright protects creative design, creative artwork, source code, HTML coding, some of the more original works of authorship on the website. So is it really yours? Another true and false. So if a company pays a graphic designer to create the website, then the company is the copyright owner of that website. Right, we have some answers in, and you guys are going to hate me because it was another trick question. It's false, but it's also, it depends, because what's required for the company to be the copyright owner of that website would be a contract that assigns the copyright from the graphic designer to the company. Copyright assignments have to be in writing. So if a company pays a graphic designer to create the website and there's no agreement, or the agreement is silent on copyright, then the graphic designer is the owner of that website. The graphic designer is the author as an independent contractor. So again, there would have to be some assignment of that copyright. And the way that we can explain this so that it makes maybe more sense is if you were to go and buy a book from Barnes & Noble, you go and you purchase the book, you own the book. So you can, you have a physical copy, you own the book, you can read it, you can share it, at home with your family members. You can do certain things with that because you own the physical copy of the book, but your rights to that book do not extend to the copyright. You can't make reproductions in the basement and start selling it. You can't, make changes. Let's say you want the ending to be different, so you're going to change the ending and resell it. There are certain things that you cannot do with that book because you haven't been assigned the rights to reproduce or any copyright to that book. So similarly with the website, the author of the website is the graphic designer. And if the graphic designer hasn't assigned the copyright to the company, then unfortunately the graphic designer still owns it. And a lot of those agreements, if you look into who you're paying to help you with these designs, a lot of them will have what's called an exclusive license to the company. So maybe because you're purchasing it, you're the only one that can use it. But that is different than being the copyright owner. Okay, I think this is maybe the last true and false question. So if you find a photograph on Facebook, you can post it on your website without issue. I think this was maybe easier, but the reason that this question is included is because you would be surprised as to how often this happens. So what you can run into for a copyright infringement issue is taking things from the internet that you did not create and putting them on your own website, which technology makes that so easy, but that obviously doesn't mean that it's okay. So if you're sharing photographs within a social media platform, so you see a photograph on Facebook and you're sharing it within Facebook to your own page, then you're under the terms of use of the social media platform. So there are ways in which you can share within the platform itself, but extracting something, there's a beautiful picture of the mountains, let's say, and you want to use it on your website and you take it from Facebook or take it anywhere else, then that constitutes infringement. And what's happening and what we see a lot with clients today is not necessarily the photographer claiming infringement, but a lot of these images are owned by rights management companies. So there's a rights management companies that own the copyright to thousands of images. They monitor the website. They screen for any posting of that photograph using coding to see if it's been posted anywhere without permission. And then they send out hundreds of demands letters in hopes that they get profit off of that, and then that they give the respective photographers some of that profit. But they're called copyright trolls. There are companies out there that they profit off of this, of scanning the internet for unauthorized use of photographs and claiming copyright infringement to get them taken down and get some settlement. Okay, I think that was it. I could probably keep talking, but I won't because it's time for questions.
Thank you so much, Erica and Peter and Angela. We actually do have a number of questions, so I'll go ahead and dive right in. The first question that was asked is, Peter mentioned the acquisition of unencrypted data in connection with a California breach. What are the panel's thoughts on whether a data breach has occurred under any data privacy laws when encrypted data is stolen? Is there an obligation on the company affected to prove that the bad actor did not also steal an encryption key, or that the bad actor would not reasonably be able to crack the level of encryption on the stolen information?
Really great question, and it's particularly timely. I used the example of if it were unencrypted because the California law specifically says any consumer whose unencrypted personal information is subject to a data breach has a right of action, and then the statutory damages would apply. It's going to depend on the jurisdiction that you're in. Some have that catch-all for if you have an encrypted data set that the encryption key has not been violated, that you're in somewhat of a safe harbor. That is not universal, but as a general matter, it's going to depend on the jurisdiction that you're operating in, rather than being a rule across the board. And I say it's timely because with the advent of quantum computing and just how much better our computing technologies are getting as a society, the ability to crack relatively weak encryption is increasing. And the Department of Commerce, for example, has started a drive to get basically quantum proof encryption that would kind of turn the tide against this. But that is something that policymakers are currently debating and considering, but right now for the laws that we have on the books, it's going to depend jurisdiction to jurisdiction. California, the example that I was making, it says unencrypted data, you get a private right of action.
Thank you, Peter.
Mhm.
The next question came in, Angela, during your session, and it was asking, do you have any commentary for businesses that describe but do not sell their product online? So there's no ordering forms or anything like that. So that might tie in a little bit with Peter's collection of data and also the ADA side. Do you want to jump in and take that one?
Yeah, so from the ADA side, as long as like the pictures that you have the, if it's captions or visibility technology. So the same rules would apply, even if you're only just posting information. So even if you don't have a super interactive website, and that's okay, you still just have to make sure that other users that have visibility can operate it. Now, from a more privacy perspective, where you're not really collecting any information, keep in mind that you're marketing the beacons, the cookies, all of these things, depending on the jurisdiction, can be considered personally identifiable information. Now, the sensitivity of such information is different. So from a privacy notice perspective, you just want to make sure that you're transparent and upfront about that and what you are collecting. So you need one even if you're not collecting information in a traditional sense of registering for an account or ordering a particular product.
Great, thank you. The next question is, with the pandemic and so many turning to teledoc or telemedicine with insurance carriers, if an insurance carrier is already an approved vendor, can you advise your client that it's safe to flip the switch and add telemedicine option for employees, or do you have additional due diligence suggestions?
I don't know that we have enough information for that one. Whoever submitted that, if you want to separately email me and Peter, and you give us a little more information around what the vendor relationship looks like and that kind of stuff, we can certainly give you some high-level response on that.
Perfect. And then the final question is, I'm just going to pose this one to the group. Can you speak to proper application of the work for hire doctrine vis-a-vis copyright, other developed work product for a website?
Yeah, I can answer that because I think it has to do with what I said, and I appreciate the question, because going back to the graphic designer true and false, if the graphic designer were an employee, then the ownership of the copyright is the employer. So that's in the Copyright Act, an employer-employee relationship. There's also a work for hire doctrine, which states that there's certain categories of works that are work for hire, that if the independent contractor is hired to and they include a compilation, supplementary work, an atlas. There's certain things in the copyright law statute that if an independent contractor is paid to provide those specific works that are set forth in the statute, then those would also be owned by the company. But the scenario that I set forth was a graphic designer that does all the artwork for the website and there's nothing in writing. So that graphic designer would be the author.
Okay. Wonderful. Well, those were all of the questions that were asked by our participants today. So thank you again to Angela and Peter and Erica for presenting today. Thank you to all of those who attended. For those of you in attendance, I did get a question about whether or not this webinar was pre-approved for CLE, and it is not. But if you'd like to email me separately, we can talk about providing some materials that you might be able to apply on your own for that. For those still in attendance, following today's webinar, you will be sent an email with a list of articles related to the issues discussed today. We'll also provide a recording of the session and a link to sign up for our privacy and data security alerts. We appreciate you taking time to join us today and hope you're able to take some of the information you learned and apply it to your own business. Thank you again, and that concludes today's webinar.